Tonight, from Boston, the advocates. Howard Miller, William Rusher, and the moderator, Victor Palmieri.
Good evening. I'm Victor Palmieri. Tonight, The Advocates begins its third season of weekly broadcasts. And it's my pleasure to welcome back those of you who were among our regular viewers last year, and to welcome those who are with us for the first time tonight. The Advocates have been introduced, but let me tell you a little more about them. Howard Miller, who returns with us for the third year, also returns this year to the University of Southern California, where he is a professor of law. And William Rusher, who joined us last year, is a lawyer, former special counsel for the Senate Internal Security Subcommittee, and the publisher of the widely respected conservative journal, National Review. In future broadcasts, we'll be drawing upon a pool of distinguished men and women in public life who will join us as guest advocates in an attempt to bring illuminating debate to the important public issues of our day. Now to tonight's question. Should the government drop charges against Daniel Ellsberg? Advocate Howard Miller says yes.
The government is about to prosecute Daniel Ellsberg for returning a set of documents to those who own them, the people of the United States. Those prosecuting are the very people who support the policy that Ellsberg exposed as a fraud. In a kind of premature 1984, the lie is prosecuting the truth. With me tonight to urge that the government reassert its integrity and drop the charges against Daniel Ellsberg are the former senator from the state of Alaska, Senator Ernest Greening, editor of the Nashville Tennessean, Mr. John Siegenthaler, and professor of linguistics at MIT, Professor Noam Chomsky.
Despite that eloquent statement, Advocate William Rusher says no.
A federal grand jury has indicted Daniel Ellsberg for violating the U.S. Criminal Code. If this happened to you or me, we would have to stand trial. But Ellsberg's friends now argue that he should be exempt from prosecution because he acted with a political purpose in mind. Is this the kind of America we want? Should there be one law for Daniel Ellsberg and another for the rest of us? With me tonight to answer no to these questions are Mr. Leo Chern, Executive Director of the Research Institute of America, former United States Ambassador Elbridge Durbrow.
Gentlemen, thank you very much. And now for some background on tonight's question. In June of 1967, then Secretary of Defense Robert McNamara ordered a secret study to be made of United States involvement in Indochina since the end of World War II. 36 persons, drawn from the Department of State and Defense, as well as from several private research organizations, worked on the study. It took over 18 months to complete, and when finished amounted to 47 volumes containing many classified documents and a narrative account highly critical of U.S. involvement in the Vietnam War, in all over 2.5 million words. In March 1971, the New York Times came into possession of a copy of the still classified study. 3 months later, it published the first of a series of articles based on the revelations contained in the so-called Pentagon Papers. A government effort to block publication of the papers was finally denied by the Supreme Court without touching the question of whether a crime had been committed. By this summer, much of the secret study had appeared in print. The government has accused MIT professor Daniel Ellsberg, who worked on the study, of having played a key role in releasing it to the press. Specifically, it has accused him of violation of the Espionage Act, which makes unauthorized possession of classified documents relating to national security a crime, and with stealing government property. Well, the issue of Daniel Ellsberg's guilt or innocence is not the only issue raised by the Pentagon Papers. Were Presidents Kennedy and Johnson guilty of deliberately misleading the American public? Is classification of documents by government frustrating a legitimate right to know? But tonight we deal with another issue, the issue of personal responsibility. Should the government drop charges against one Daniel Ellsberg? That's the question we considered tonight. And now to the cases. Mr. Miller, tell us why the government should drop those charges.
The question is often asked, What if others do what Daniel Ellsberg has done? The answer to that question is another question. What if they don't? If at this moment another Vietnam were being planned, secretly and deceitfully, wouldn't we want another Daniel Ellsberg to tell us about it now? In fact, Daniel Ellsberg has breached no law. The law under which he was indicted required that it result in injury to the United States. The disclosure has resulted in benefit to the United States. What Daniel Ellsberg did is commit the unforgivable sin. He breached the wall of secrecy between the government and the people. But many others have done so. In the New York Times case, Benjamin Bradley, the editor of the Washington Post, submitted an affidavit which stated that on Wednesday, June 16, 1971, he visited the offices of Holt, Reinhardt, and Winston in New York City, where he was shown galley proofs of former President Johnson's book, and that many other editors, reporters, and newspaper syndicate representatives have had the same opportunity. Bradley goes on. The manuscript contains extensive verbatim quotations from classified documents contained in the materials involved in the Ellsberg case. Can we permit an ex-president to sell classified information for profit and at the same time prosecute an ex-official who releases it for the public information and good? To speak to the point that Daniel Ellsberg should not be prosecuted, our first witness is Senator Ernest Greening.
Senator, we're very glad to have you on the Advocates.
Glad to be here.
Ernest Greening has been senator from the state of Alaska and was one of the 2 United States senators to vote against the Gulf of Tonkin resolution. Senator Greening, should we prosecute Daniel Ellsberg?
Certainly not. Not only should he not be prosecuted, but he should be rewarded. He should be honored for the inestimable, valuable service that he has rendered the people of this country.
What is the service that he has rendered?
Well, he has exposed the deception, the betrayal of the elected public servants of their responsibility to the American people. He has exposed how the leading officials, starting with the president and all his surrounding advisors, lied the American people into this war with the countless deaths and wounded and all the other disastrous consequences. He has exposed how the Tonkin Gulf Resolution was a completely spurious episode and how the Tonkin Gulf Resolution had been drafted months before by an Assistant Secretary of State before the Tonkin Gulf episode happened. He has exposed how while Lyndon Johnson was campaigning for election in his own right and telling the American people that he would never send American boys to fight a ground war on the continent of Asia, that he would never send them to do the fighting that Asian boys should be doing. All the time he was planning to do this and escalating the war. This is an important revelation of inestimable value to the American people. It will make them alert in the future to see that this sort of thing can't happen.
What is the effect of the classification or secrecy system he is supposed to have violated?
It merely keeps the American people in ignorance while it does not conceal these facts from the enemy.
Has Ellsberg's disclosures caused any harm or injury to the United States as is required for him to be prosecuted and convicted?
None whatsoever. On the contrary, they have done unmitigated good.
What is, and the good that they have done is what you've previously described.
Well, they show the American people that even their elected officials can't be trusted, that they have been betrayed by them, and that this betrayal may be going on right today. It has alerted the press to be far more vigilant in safeguarding the public interest than it has been through this tragic Vietnam affair. If the press had performed its full duty, we might not be in this horrible mess. And this is one of the many services he's rendered. And another service that he's rendered, he has shown up how utterly valueless and wrong this classification system is, by which any pipsqueak official can stamp a document and call it top secret, and keep this information from the American people, whose duty it is, whose responsibility it is to have this information so they can exercise their franchise intelligently. The whole issue of government by consent of the government is involved. And so Ellsberg should have the equivalent of a Congressional Medal of Honor if there was such an award to be given to a man in civil life.
Thank you, Senator.
Senator, Mr. Rusher has a habit of asking some questions at this point.
Hard habit to break. Senator, you were in the Senate, I believe, until 1968 when you were defeated by Senator Gravel.
That's correct.
This was then during, at least the latter part of your term, was during President Johnson's administration. I take it you are saying, I think you did say flatly, that he lied to and deceived the American people.
Yes, I did, and I say so now.
Yes, and specifically that while campaigning on the grounds that he wasn't going to get into a war, he was planning.
Yes.
I call your attention to the fact that Leslie Gelb, who was the coordinator of the whole Pentagon study, the editor of the whole series, writing in Look magazine September 17th of this year, said, and I'm quoting directly, President Johnson, before the 1964 elections, was not part of the general consensus of our government to bomb North Vietnam. Our studies depict him as quite resistant to this course. You think Mr. Gelb was wrong?
No, I think Johnson yielded to persuasion. He became a hawk after he had resisted somewhat feebly for a while.
That's not quite what you said a moment ago, though. You testified to Mr. Miller that Johnson had been lying to the American people in campaigning. Not according to Mr. Gelb. He was resistant at that time to the bombing. Now, who's right, Mr. Gelb or you?
I'm right.
You're right, and the man who investigated the whole subject and edited the 47 volumes is wrong.
I had my information long before the Pentagon Papers appeared.
The Pentagon Papers are wrong in this respect?
No, they're not complete. They don't tell the whole story.
Indeed they don't. I agree with you.
They tell a good deal, but they don't tell everything.
And you say there was no harm from these papers?
No harm, only good.
Although, oddly enough, Justice Byron White, who was appointed to the Supreme Court by President Kennedy, and who concurred in the majority which ruled that they would not enjoin the Times and the other papers from printing these documents, said in the course of his concurring opinion, I am confident that their disclosure will do substantial damage to public interests. Was he wrong, too?
On the other hand, Justices Black and Douglas thought otherwise.
Precisely.
And I think they have a greater standing in history than this other justice.
So we now have...
Justice White.
We now have Mr. Gelb, the coordinator of the Pentagon Papers, wrong about Johnson, and Justice White, Kennedy's appointee to the court, wrong about the
I don't say that he's wrong. He's just incomplete. He doesn't tell the whole
like
story.
Like the papers, yes. But when he says that he's confident that their disclosure will do substantial damage to the public interest, he's either right or wrong and not just incomplete, isn't he?
Well, it's a matter of opinion. He thinks it does no damage.
And you think it does?
I think it's a very useful service.
Right. A matter of opinion. Tell me, do you think that secrecy is necessary to the conduct of government?
Very seldom. I think we've had far too much of it.
Would you comment on this statement that even when negotiations are brought to a conclusion, a full disclosure of all the measures, demands, or eventual concessions which may have been proposed or contemplated would be extremely impolitic?
No, I wouldn't agree with that at all.
That was President George Washington, I should tell you, sir.
I think that,
was he wrong, too?
I think that when the thing has taken place 3 years previously, as in the case of the Pentagon Papers, the American people are entitled to that information.
President Washington will just have to join Mr. Gelb and Justice White among those who
No,
were wrong.
President Washington was dealing with an entirely different period in our history.
Right. Can you tell me if some future Ellsberg chooses to reveal delicate negotiations concerning the Middle East, do you think that he has the right to take those to the papers and publish them?
Well, I don't know that it makes much difference whether it's the Middle East or the Far East.
Well, I'm using the Middle East as my hypothesis, if you will do the same.
I see no difference. I think the basic fact is that the American people are entitled to disclosure of what their public elected officials are planning to do for them or to them.
Precisely.
With that, Senator, excuse me, Bill.
Fine, surely.
With that, Senator, I'm going to have to move on. Thank you very much for being with us tonight.
The government secrecy is not only a system that keeps the people from knowing, but selectively keeps them from knowing and allows manipulation. And to talk to that point, I have asked to join us as a witness Mr. John Siegenthaler.
Welcome to the Advocate.
Mr. Siegenthaler. Mr. Siegenthaler is the editor of the Nashville Tennessean, former administrative assistant to Attorney General Robert Kennedy, the author of the newly published book, The Search for Justice. Mr. Siegenthaler, are classified materials regularly made available by the government to newspapers in Washington and elsewhere?
Yes, I would say that it's rather a routine matter. First of all, the ridiculous method in which documents are classified means that almost every ranking official, many non-ranking officials, has a flood of classified material that crosses his desk every day. I would say that it's not at all unusual every day at lunch or over cocktails in the afternoon.
Can you give us any examples?
Well, just while I was in the Department of Justice, I would have conversations periodically with officials of government who had had luncheon meetings with newspaper reporters and would discuss matters which I would have seen contained in classified documents earlier.
Has the Nixon administration, in fact, rewarded someone who?
Well, there is the case, of course, of Otto Otepka, who was, in 1963, was a ranking official of the State Department who leaked material of a classified nature to an employee of the United States Senate, and this administration, of course, has rewarded him by giving him a job on the Subversive Activities Control Board.
Where he monitors others who leaks.
For twice the pay that he got when he was in the State Department.
Are there examples relating to information about the Vietnam War, however?
I think there are a number of examples about the Vietnam War. There are, first of all, a whole series of books that have been published by journalists and former officials of government, which classified materials have in that way been communicated to the public, and some of them, I think, are as sensitive, so-called, as the Pentagon Papers. The book by Stuart Lurie and Dave Kraslow, who are Washington correspondents for the Los Angeles Times, is one book on Vietnam of that nature. There's a book by Roger Hilsman, one by George Christian, former aide to President Johnson.
But why is it then that those people were not prosecuted disclosing that kind of information and Daniel Ellsberg has been?
Well, I think the prosecution of Daniel Ellsberg is selective law enforcement at its worst. It's a political prosecution. The Ellsberg disclosures have embarrassed the continuation of this war and have thereby embarrassed this administration, and it seems to me that that's why he's being prosecuted and others are not.
I'd like to shift cross-examination with that very significant statement. Mr. Usher.
Mr. Siegenthaler, you were, as Mr. Miller told us, administrative assistant, I believe, public relations representative for...
I was not public relations.
Not public relations, but AA to Attorney General Kennedy, Robert Kennedy.
Administrative assistant.
Did he habitually leak classified documents to the press?
I don't know of any classified documents he habitually leaked.
Did he intermittently leak classified documents to the press?
I don't recall that he did.
You don't. Was he an
He
exception?
did not in my presence.
Not in your presence. Do you have any reason to suspect he did it out of your presence?
I suspect that he had conversations, as most of the officials in the Department of Justice had conversations with newspaper
Right.
men,
Oh, yeah.
and I would say on the question of classified documents, it's almost impossible to have a discussion with anyone and not divulge classified information.
Well, now, yes.
Everything is
but this is a
classified.
distinction I think that's rather important to make. Having a conversation with a reporter, a government official like Attorney General Kennedy doing it, is undoubtedly going to touch upon matter that is also contained in classified documents. Do you see any difference at all between doing that kind of a thing and actually taking the classified document and giving it?
I think
to the reporter?
I think that's a distinction and not a difference.
And
A
not a
leak is a
difference.
leak.
Would you say that giving such a document to a reporter, assuming it was given rather than just referred to over cocktails, is a little bit different than giving the New York Times 43 volumes containing 4,000 pages of documents and 2.5 million words? How many cocktails would it take to...
Well, again, I think that's a distinction and not a
not a
difference. It would
difference.
depend upon what was in the material as to whether you could get that much out over a cocktail.
In the case of Otto Otepka, I'd say after the number of cocktails that'd take, you wouldn't be getting much out of the documents, but perhaps I'm wrong. In the case of Otto Otepka, whatever we think of what he did, the fact is that he was an employee of the executive branch who gave documents to the Congress, an employee of the Congress of the United States, right? And
That's right.
Daniel Ellsberg was a contracted employee of the government of the United States who gave the documents to newspapers outside the government of the United States altogether.
That's right.
So this is another one of your distinctions without a difference.
Well, I think in the case of Otto Otepka, what he leaked was in large measure meaningless.
Right.
I don't know of any newspaper men that would be interested in what he leaked.
I see. Can you tell me, as the editor of the Nashville Tennessean, do you believe that your reporters have the right to conceal their sources?
Yes, I do.
If one of them defected from your paper and published records showing all of their sources, would you consider that that man should be prosecuted?
No, I would not.
You would not.
would
You
not.
would certainly not encourage him to do that.
I would
kind
not
of
encourage
thing,
him.
no.
I wouldn't enjoy reading about myself,
And,
but I wouldn't want to put him in prison for it.
You would, in other words, we can be perfectly clear that if anybody steals documents from the Nashville Tennessean and leaks them to other papers, no prosecution will ensue. You guarantee us that?
I don't want to invite anybody to break into the
Of
office
course
tonight.
not, but you're inviting people to break into the government of the United States.
I
and
don't
do the
think he
same
broke
thing,
into
so-
anything.
No,
I'm
but
not
Ellsberg
inviting.
did.
Ellsberg did in large measure what most of the former officials of government have done, who wrote books and used their own documents that they took home with them as a basis for telling the American public about what went on in government as they saw it.
Suppose Otto Otepka had leaked those classified documents to the press rather than to the Internal Security Subcommittee of the United States Senate. Would you favor prosecuting?
There are newspaper reporters who've told me they had access to them, but they're not really meaningful,
You would
I
not
think.
favor prosecuting him. Let's be clear of that.
I would not favor
You would not,
prosecuting
right.
Otepka.
And when I tell you that the Constitutional Convention in 1789, a subject whose deliberations even the Nashville Tennessean might have considered newsworthy, voted to conduct all its deliberations in secret, would you say they were wrong to do so?
Yes, I would say they were wrong to do so.
Along with President Washington, I guess.
No,
I have
would-
no further questions.
I would say they were wrong to do so, but I would say that it's a totally different world we're living in.
Absolutely, apparently so.
Well, let's hope so. The Founding Fathers are having bad luck here tonight, aren't they? Mr. Siegenthaler, thank you very much for appearing on The Advocates. Mr. Miller, you've got a statement to make on this part of your case, right?
We've heard from Senator Greening that the purpose of the secrecy system is to maintain secrecy from the American people, not from anyone else. From Mr. Siegenthaler that the secrecy is selective, that in fact officials regularly publish, and for profit after they leave office, the same kind of classified material. Are we then to reward deceit and punish the man who honestly publishes them for the public good? The question that all who prosecute Daniel Ellsberg must answer is, if he is prosecuted, what about the hundreds of other ex-officials of government who in their books about Vietnam and other places have released similar classified documents? Are they to be prosecuted also? And if not, why is Mr. Ellsberg different?
Thank you, Mr. Miller. Mr. Miller gets the last word tonight because he's presenting the proponent's case, and we'll be back to him for his rebuttal. Now let's hear from Mr. Rusher, the other side of the case. Mr. Rusher, why should the government not drop the charges against Daniel Ellsberg?
Let us begin by conceding at once that Daniel Ellsberg is no ordinary criminal, that whether he is right or wrong about the Vietnam War, he sincerely believed he was right, and that he committed the crimes in question with the best of political intentions. What you and I must consider is whether, in those circumstances, he should be completely immune from prosecution, as Mr. Miller and his witnesses contend. There are, it seems to me, two major considerations that must be borne in mind. The first is that in an orderly society, laws are meant to be enforced, and to be enforced uniformly. Plenty of crimes are committed in this country by people who don't think of themselves as criminals, but we can hardly start turning loose every person who commits a crime, provided he can prove he had a political motive for committing it. That, as Mr. Chern will tell you, is the end of true justice in America and would set a precedent that would return to haunt us again and again. Second, there has been a major effort tonight to persuade you that Daniel Ellsberg's crime was at most a purely technical one, a crime that didn't hurt anybody, a crime indeed that had only desirable political results. We are going to show you, on the contrary, and despite Mr. Ellsberg's sincerity, that his acts had very harmful consequences indeed, that they have damaged our relations past and future with over a score of foreign countries, including some of our closest allies, that they have made it virtually impossible to conduct effective future investigations like the very Pentagon study he stole and distributed, and above all, that they have severely compromised the security of this country in ways Mr. Ellsberg may not realize even now. To talk to the first of these points, I call upon Mr. Leo Chern.
Welcome, Mr. Chern.
Mr. Chern is Executive Director of the Research Institute of America and Chairman of the Executive Committee of Freedom House. Mr. Chern, is this controversy over Mr. Ellsberg a dispute between left and right, or between hawks and doves, or something of that sort?
Well, it tends to be seen that way at present. Just as 20 years ago, nearly the identical question was seen in exactly the reverse, and I'm referring to the occasion when Senator Joe McCarthy similarly thought that he had a uniquely patriotic right to secure information in the interest of the nation, and without regard for what it is that information did, either the government or the individuals involved.
Well, how then should this case be regarded? What is the central question?
I think the central question inescapably is application of the law to be selective, arbitrary, subjective, political, or is it to be certain? Now, if it's to be selective, make no mistake about it, however much we may agree with the non-application of the law in a particular case, we have either tyranny or anarchy. Now, in Mr. Ellsberg's case, oddly enough, it violates precisely that which he himself said he wanted to do. He defines his act as an act of civil disobedience. Civil disobedience is an honored course of action because it is the course of an action of an individual who believes in principle sufficiently to risk the punishment certain for the offense in order to make the principle visible. If now, having committed the act, he is to be free of punishment, or at least of discovery, is he guilty or innocent? I haven't any idea. I will not until a court has concluded. Then it is not civil disobedient. It is neither civil nor disobedient.
Didn't the Supreme Court, in the case of the New York Times, in effect rule, at any rate, that no crime had been committed here?
Supreme Court ruled no such thing. Supreme Court ruled on a simple question. Did the court have the right of prior restraint against any newspaper from publishing information it had in its possession? Let me say incidentally, I believe the decision of the Supreme Court, my own personal view, was a correct one.
Well, then what is the biggest danger, in your opinion, sir, in not prosecuting Daniel Ellsberg?
Well, the biggest danger is we don't really perceive what it is we've let loose. We are now in stage one of what is virtually certain to be a two-stage witch hunt. Stage one is the effort to find out who got us involved in this war. Stage two may be a great deal messier than that. It will involve the search for those who are responsible for having lost the war. These primitive polar passions, if they each have access to whatever it is that lies in files, secret documents, dossiers, we are back in the days of 1950 to 53.
Very briefly, and aside from the question of simply even-handed justice, is there any positive advantage then to be gained from prosecuting Ellsberg? And if
Yes,
so,
I see here, I must say, I do agree with Daniel Ellsberg. He urges the importance of the public knowing as much as it may legally be told. He goes beyond the point of legality, I would observe. Well, he has said, he's made a most remarkable assertion. He says he is the only one of all those 30-odd scholars who had access to the complete documents. Now, if that's true, then this is not history that has been written. It is a parody of history. If, on the other hand, it is not true, we need to know that about Daniel Ellsberg.
thank you.
Mr. Chern, can we explore the balance of your views on cross-examination?
Sure. Let's talk about uniform enforcement. Should ex-President Johnson be prosecuted because he released some of the same classified material in his book at Holt, Reinhardt, and Winston?
I deplore the actions of presidents and assistants to presidents.
George Christian?
I deplore, excuse me?
George Christian, who in his book on the peace negotiations released even more sensitive classified material.
I'm not familiar with that particular work, Mr. Miller.
Well, but is your position that ex-President Johnson should in fact be prosecuted?
No, it is not.
Well, but
it is clearly not.
But why not? He released classified documents.
Let me say why not. First of all, it would be virtually impossible for a president having sat at the very center of every fundamental decision of the years in which he was office to even live and breathe.
Same documents.
Live and breathe.
Documents, Mr. Chern. Let's be clear what we're talking about. Mr. Bradley's affidavit says the same documents are in the Johnson book. Should President Johnson be prosecuted?
By the application of my principle, I would have to say yes.
Yeah, and George Christian, one of his
who
released the same documents?
I must confess my ignorance. I do not know the George Christian to whom you refer.
It seems to me you've bitten the larger bullet.
Yes.
Right.
I don't think you have to worry too much about it.
Well, I think you do. Let's talk about David Kraslow. In the Pentagon Papers themselves, it released that the CIA released classified documents to the South Vietnamese at the time of Diem coup to convince them that we in fact supported the coup. Should those CIA officials be prosecuted?
I believe not.
Why not?
Because I believe they have in turn been instructed by government to perform one of the ugliest roles, one I deeply deplore, but it is a role inseparable from the fact of an anarchic world in which war does exist. not by our choice.
And what about Roger Hilsman, an ex-Kennedy official who contains in his book the same sort of classified
well, let
information?
me say
Should
that
he
in
be
the case of
prosecuted?
Roger Hilsman, I think he now faces perhaps a larger embarrassment than prosecution, that there does appear to be a discrepancy between certain of the events as he has described them in his book and those same events as they seem to emerge in the Pentagon Papers.
Well,
But now, may I say a word for Roger Hilsman? These Pentagon Papers are one of the vilest exercises of all in something else, anonymity. We do not know the scholars. We do not know their qualifications. You, I'm sure, were as appalled as I when faceless men made accusations 20 years ago.
I'm appalled that I may not be able to get to ask you another question.
That would not disturb me, Mr.
Well, I know that, and that's why. Now, let's talk about the uniform application of law. If President Johnson is not being prosecuted, George Christian, David Kraslow, Roger Hilsman, if in fact in the entire history of the United States there has been only one other prosecution under the statute in which Daniel Ellsberg is being prosecuted, is it uniform prosecution then to prosecute him or not to prosecute him?
Well, let me say that in my entire recollection, there's been only one other individual so monumentally indifferent to the process of law.
Well, I'm giving you
and that
other
other
examples.
individual was Joseph McCarthy, who, for example, said that I feel it is the duty of all those who have information to give it to me. There is no loyalty to a superior officer which can tower above and beyond their loyalty to their country as I have defined
The
it.
difference,
Mr.
the
Chairman,
difference between Senator...
I want to exclude documents which are not responsive to the question. We only have time for one or two more questions.
I would say the difference between Senator Joseph McCarthy and Mr. Ellsberg is that Mr. Ellsberg information happens to be correct. Now, let's go on in this point about uniform prosecution. You would then...
May I
We
just
have 30
respond to that?
seconds.
What are the purposes of having this ventilated in a courtroom? Is in fact to find out whether some of the things he has said are correct
Yes, you mentioned
or are
that-
not correct.
But you mentioned that Dan Ellsberg himself may want a trial. Would you agree the president should drop prosecution if Mr. Ellsberg does not want a trial?
I do not. I
course
do
not.
not believe the question of whether or not an indicted individual should be tried should be an arbitrary choice, either of the prosecutor or the
But
defendant.
in fact it is. Every day in the United States, thousands of people who are indicted are not tried. The prosecutor always has discretion not to prosecute
And
the
you,
indictment. Does he
Mr. Miller,
not?
I believe,
Does he
found
not?
it attractive to practice the law because of your conviction that, fallible as it is, that practice of the law is the only means by which a safe, democratic society can be preserved.
Precisely because the prosecutor has the discretion in the case which is incorrect. In this country today, there are thousands of prosecutions being dropped at the discretion of the prosecutor. You're not telling us the prosecutor by law is obligated to prosecute because there's been an indictment. That's simply not true.
Gentlemen, that ends our cross-examination. Mr. Chern, thank you very much. Mr. Rusher.
I think Mr. Miller will find when he has practiced a little more law that it is extremely rare to drop a prosecution after an indictment has been obtained. The time to stop is before the indictment which has been obtained against Mr. Ellsberg. Deal with President Johnson a little bit later. I want to call now to determine the harm that is done by Mr. Ellsberg upon former Ambassador Elbridge Durbrow.
Mr. Ambassador, welcome to the Advocates.
Ambassador Durbrow was formerly in 1957 to 61 ambassador to Vietnam and then alternate U.S. representative to NATO until 1967. He also served in the Foreign Service 6 years in Moscow on 3 separate assignments. Ambassador Durbrow, just how great was this service that Daniel Ellsberg performed for the American people?
In my estimation, unfortunately, he did a great disservice to the American people
Why is that?
because the documents that he released, some 43 volumes, very voluminous, but they were very incomplete. The anonymous 36 authors had access to only the Pentagon Papers, which included State Department, CIA, and NSC papers to a certain extent, but not all of them by any means, and none from the White House. So the American public has been asked to read the interpretations given by the news stories on this thing and to try to make a judgment on incomplete information. And for that reason, I think he did a great disservice.
And the selectivity exercised
Well, I
made it work.
referred to that. the original group, the newspapers, picked out certain documents they thought were pertinent to this particular problem. Each one picked different documents or for a different purpose, and that led to another story, analysis by the original ones, and the newspaper men, headlines, and the implications in the leads. So the public was more confused than ever by getting complete, quote, factual information that didn't give them a chance to make a clear distinction and to get a good picture of the situation.
Well, if it wasn't then any real good that the documents did, what actual harm can you say it did aside from this confusion and distortion? Take first our relations with other countries, if you will.
Well, having been almost 40 years in the diplomatic business, the confidentiality of your negotiations, your talks, your dealings with your foreign colleagues is vital and critical. We could not carry on foreign relations without it. The fact that many things that our foreign colleagues have told us come out of these Pentagon Papers is going to make it more difficult, and in some cases probably impossible, for us to have meaningful, confidential discussions with our allies, which are very much in our interest to have. Actually, some 4 or 5 countries have already formally protested the publication of these documents. Other countries have given oral protestations, either abroad in their countries, respective countries, or in Washington, about the publication of these documents, thereby making it much more difficult for us to carry on our business in the protection of the United States.
And how about carrying on our negotiations in the future?
Future negotiations will be much more difficult. First of all, the countries have protested, as I said, and I'm sure dealing with our enemies or with our friends, dealing with the SALT talks, the disarmament talks, if you will, in Helsinki, just finished the other day for that stage of it, and the in Mideast question, they have to be done very confidentially.
I will have to, since our time is short, skip one other question I'd hope and go directly to my last. Has any damage been done to our security, sir?
Yes, in my estimation, a great deal of damage has been done. The documents give code names to some of our projects that were ongoing. The enemy learns this. He's heard about this code project, didn't know really what it was all about. He gets a verbatim text, and he starts running it through other sources and gets a much better picture and harmful to the United States. Actually, in the parts of the Pentagon Papers which were released, 60 documents from the State Department and 30 documents, off and on, give a number of 1 or 2, from the Pentagon, did deal with ongoing U.S. diplomatic, intelligence, and military negotiations today. So it's done a great deal of harm, in my estimation, to our security.
What types of negotiations?
POWs, the third countries we're going through to try to get peace talks going with North Vietnam and matters of that kind.
And those operations have been compromised now?
I think they all have been compromised.
Mr. Ambassador, let's go to cross-examination. Mr. Miller.
Please.
In fact, Mr. Ambassador, the 4 volumes of the study that dealt with ongoing negotiations were not published, were they?
That's correct, yes.
Well, how could they have done us harm?
Well, I'm talking about the ones, the 60-odd and 30-odd documents were in those 43 volumes that he did release to the press.
But the documents enclosed with current negotiations about Vietnam, those documents were not published.
The things that were disclosed, as I understand it, did deal with things of that kind today.
Well, name
ongoing
one.
U.S.
Name some, for example. What
I
code
don't know
names
the
were
details. I'm no longer active, but
We're suggesting that Daniel Ellsberg go to jail for this, and you say he's compromised the national security. Like the boy who didn't want to eat spinach, and his mother said, think of all the children in China who'd love it, and he said, name 3. So I'm saying to you, name 3.
Well, I know that these disclosures in the volumes that were given out did deal with such things as our channels of operation.
What channels?
Intelligence channels,
With
diplomatic
whom?
channels, with third countries trying to
Which
make
third
peace in
countries?
Vietnam. I'm not in a position to name those.
It's so secret you can't tell us about it.
I can't, yes.
You can't.
I cannot, I
You
say.
cannot, because so we're to say now that there's
trying to
been
work
harm
out
because...
our POW releases and things of that kind. Now, why didn't Ellsberg let the 4 volumes out? Would they have changed the whole picture, or was he doing that out of patriotic reasons so the public would not know what was in those documents?
But Ambassador Durbrow, you can't tell us, for whatever reasons, though you talk grandly of breakdown in negotiations and code names, you can't tell us any specific instances in which there have been harm.
I am not privileged to disclose that information in public, no.
Now tell me, do you think the United States, the people of the United States, were helped or harmed by learning that there were covert operations against North Vietnam as early as the spring of 1964?
I hope they were helped.
Were they
That
helped?
We do have that kind of a American that's willing to risk his neck or train other guys to risk their necks to try to help us help our friends.
Well, and what about the disclosure that as early as the summer of 1964, Thai pilots were bombing North Vietnam with American assistance? Was the American public helped or hurt by that disclosure?
I don't see how they were harmed if they were doing this thing in the interest of freedom and keeping another country free. I'm all for freedom.
And
myself.
what about the report of the study?
I'm not sure, Mr. Miller, that the ambassador is either hearing or understanding your question. He's asking whether the American public is hurt by the disclosure, not by the act. And you seem to be answering with respect to the act. Was the American public, as I understand the question, hurt by the disclosure with respect to the Thai bombing?
No, I don't think so at this time. But I bet you 80, well, I think they said 95% the other day of the things in the volumes that were released, the 43 volumes, were not that important. But there were these other things which are still ongoing negotiations, channels of operations in the intelligence field and so forth that are important, and they should not have been disclosed.
Tell me, Ambassador Durbrow, do you think there are any circumstances, if you were to learn, suppose you were to learn of American officials, your superiors, planning an act that clearly constituted a war crime, in your view and in general view. Do you think there are any circumstances under which you would disclose confidential information to fight that?
I would do all I could through the proper channels to see that they didn't do it if we possibly could
And
stop
if the
them.
proper channels told you no, you'd say your superior officers have ordered you and that's it.
Well, I don't know what the supposition would lead to. If it was bad enough, I might, but I don't think so.
You think there are circumstances under which an individual might have the obligation to disclose confidential information?
I cannot imagine any, but other people think differently.
Tell me about whether these other things that were disclosed. For example, we learned about through the Ellsberg paper and others that the basis for the Gulf of Tonkin resolution, in fact, was tainted, to say the least. Do you think the American people were given a service by that to learn about the real facts, the actual facts of the Gulf of Tonkin incident, or would it be better not to have them know?
I still say the president is the one that makes the decisions.
Oh.
The Ellsberg papers, the Pentagon Papers he released, were only part of the story.
Well, then suppose
The
you
internal
knew.
memoranda in the State Department, the Thursday luncheons that the president had with McNamara, Rusks, and Dick Helms, and the papers that he was given that didn't get into the Pentagon Papers are the things that he had the full picture and made that decision, Gulf of Tonkin or whatever it was.
All right. Now let me put those questions together. Suppose you were one who knew that, in fact, the basis on which the Gulf of Tonkin resolutions were being asked for did not exist, either fraudulent or simply absent, however we wish to construe it. You knew that. The United States government was going to Congress, in effect asking for a quasi-declaration of war. Would you feel it was your obligation to disclose that the facts being brought to the Congress were false?
What I know about the Tonkin Gulf incident, which led to the resolution, I was all for it.
Even now, knowing that...
Yes, I don't know the whole story. I don't know what the
You
president...
haven't been reading the
actually says.
newspapers.
No. I read all the newspapers very carefully, naturally, but what the president had when he decided to ask the Congress to put in that resolution, I don't know.
But if you knew, in fact, it was false, there's substantial evidence it was false, aren't there circumstances under which you would feel duty-bound to, in fact, disclose that information?
I certainly would not. I don't want to help our enemies any way we possibly can. I would go to my superiors...
Who are our
and-
enemies in that case?
The North Vietnamese.
Then why do we have to keep the information from the American people?
At that time, that's when we were working to get them to go home.
Do you think
at
the
least.
current classification system, as it's constituted, should be changed?
Surely, yes.
In what
There's
direction?
too much.
There's too much, far
There's
too
too
much
much. There's
classification.
too much.
And in fact, simply releasing a document that's classified is not a violation of law.
It depends what the document is.
Well,
about.
but it has to cause injury to the United States.
Yes,
And,
basically.
and the only injury to the United States you're willing to tell us about or injury you can't tell us about.
Basically, yes.
Yes, thank you.
Well, I'm glad we can close on a point of agreement.
Good.
Ambassador, we're very grateful to you.
Thank you very much.
Thank you very much. Mr. Miller, Mr. Mr. Rusher, you have a closing statement at this stage of your case.
30 seconds. I said I would return to the matter of President Johnson. I would simply like to make this observation. The President of the United States, any of them, their private memoranda are classified, I guess, by definition. Certainly they are not open to the public. Presidents who then proceed to write to write books about this kind of thing are obviously going to be dealing in very large part with what they have said and with communications reaching them classified for the purpose of reaching them. It is, however, under our law, the President who has the power both of classification and declassification. If we disapprove of what he does, then the thing to do is to change that law. But as long as he is the one who has the right under the law to do the classifying, we can hardly complain if he himself exercises the right to declassify a document. And I don't consider that if Johnson, who was no favorite of mine, did that, it was necessarily to be compared to a little character in this particular study who stole 2.5 million words of documents, 4,000 documents altogether, and gave them to the papers he preferred. Nonsense.
Well, thank you, Mr. Rusher. Now, Mr. Miller, it's time for your rebuttal.
Bill, I'm delighted to see you both embarrassed by and having to defend President Johnson. In fact, the President, whatever the classification rules are, can no more release documents that injure the United States than anyone else can, and that's what we're talking about, because that's what must be shown for the prosecution of Daniel Ellsberg to proceed, injury to the United States. And really, the whole thing is beyond belief, because what we've been told is the only injury that existed is injury we can't tell you about because it, in fact, is secret. If that is the basis on which Daniel Ellsberg is being prosecuted, then these charges should have been dropped long ago. To talk to us not only about what Daniel Ellsberg did, but perhaps what he had a duty to do, I've asked to join us tonight Professor Noam Chomsky.
Good evening. Professor, we're glad to see you here.
Noam Chomsky is professor of linguistics at MIT and has been active in the peace movement. Professor Chomsky, why did Daniel Ellsberg do what he did?
Dan Ellsberg released to the American people information, historical information, about how a series of presidents enmeshed them in a vicious and costly war of aggression. He had every reason to believe that this war was continuing and would continue at the present incredible level of violence. And he hoped, I hope correctly, that if this historical information were brought to the American people, they would do something about it and stop that war.
May he in fact have had a duty to disclose the information?
I think he definitely had a duty, perhaps not a legal duty, but certainly a moral duty to bring to the public evidence about criminal acts. And that's in effect what the Pentagon Papers reveal. They are a history of a criminal conspiracy operating in secret to enmesh us in this war of aggression.
We're told that one of the harms of releasing the papers, though we aren't told exactly what, is harm to ongoing negotiations. Could that possibly be true?
Well, I don't recall, of course I haven't seen the full documents, but I don't recall a single instance in the documents that deals with ongoing negotiations. There is material, very interesting material about negotiations. For example, the documents reveal in 1964 that there was a concerted effort by the executive branch of the government to avoid negotiations which they called premature, because they knew that if negotiations took place at that time, and if there were a peaceful settlement, then the client government that they had instituted and were maintaining by force in South Vietnam could not maintain itself. So therefore they violated their legal obligation to avoid the threat and use of force and to pursue negotiations and other legal means. And they said, no, we have to act in such a way as to put off every negotiation effort. And we have to first, for example, William Bundy on August 11th, 1964 said, we first have to make sure they're hurting. We first have to apply the use of force. And then maybe after we've hurt them badly enough, then we can go to negotiations.
We've heard that Van Ellsberg's disclosure of these documents may have an inhibiting effect on similar confidential planning in the future. Is that something we should be afraid of?
I hope that it does have such an impact. If there is planning going on about engaging the United States in criminal acts of aggression, I think that information should be brought to the American public, or the right people to know about it and the right people to stop it.
Thank you, Professor Chomsky.
All right, Mr. Rusher.
Mr. Chomsky, just to put your own views in the picture a little bit, in your book, American Power and the New Mandarins, you say that Americans should struggle to, and I'm quoting directly, to remove the heavy Yankee boot from the necks of oppressed peoples throughout the world.
Definitely.
That's your opinion.
Absolutely.
This is your notion of what the United States is doing, putting the heavy Yankee boot on the necks of oppressed
Yes.
peoples around the world.
Many, many such cases.
Certainly make it understandable why you feel the way you do. Would you favor prosecuting a person who avoided the draft in protest against the Vietnam War?
Certainly not. I've always supported draft resistance and will
What
continue
about
to.
a person who deserted?
No, I think that deserters should be supported.
What
In
about
fact,
people-
anyone who is resisting this illegal
What
war
about
should
people
be
who
supported.
destroy military files or ROTC property as a protest against the war?
Well, when you get to destruction, it becomes more ambiguous, but in many instances, I would support
In
it.
many instances, you would.
Yes.
What
I
about
wouldn't do it,
people
but I
who
would
would
support it.
derail a troop train?
That's even more difficult because at that point
They're getting more difficult.
That's right, and there is no. I should say that you're not going to find any general principle that applies to this case.
I
You have to
suspect
deal with
I
each
am.
particular instance. No, you have to deal with each particular instance on its merits.
Well, I'm dealing
And
with this one. How
right.
about derailing a troop train?
No, I wouldn't do that
You would
because of
not
the
do that.
injury to the individuals.
Suppose
and
nobody were injured.
if you could be certain in advance that
Yeah.
no one would be injured, then
You
I
would
think it would be
derail
all
the
right.
troop
yes.
train also.
For
What
example,
about-
I would derail a train that was carrying live ammunition to be
Sure.
dropped on the people of Vietnam.
What about Ellsberg if he had distributed the 4 volumes he withheld? Would you have prosecuted him for doing that?
I have no idea what's in those 4
I
volumes.
see. Yeah, well, the implication for Mr. Miller was that this was the really hotly packed security stuff. and
We
he
have no,
withheld it.
that's not the implication because he has no idea what's
Mr.
in those
Miller has
volumes
no
either.
more idea than you do. You're quite right, yes. Should Ellsberg have revealed this material, assuming it was security matters having to do with ongoing operations affecting the Vietnam War?
That depends entirely on what the social consequences would be of revealing that
And
information.
who would determine that?
Well, in the case of very serious criminal acts, such as the act of, say, killing, maiming, and driving
I mean,
from their
who would-
homes half the population of Vietnam, I think any American citizen has the right to
Ellsberg
make that
himself
decision.
is the one who would have
Absolutely.
to make the decision. right?
Yes, because we're dealing with very significant and ongoing criminal actions.
What if an opponent of Mr. Nixon's new initiatives toward Red China, somebody who opposed it, let's say a right-winger in the government, leaked classified documents that went back and forth, we may assume, preparing it, and that this getting into the hands of a hostile press had derailed those negotiations? Would you consider that such a person should be prosecuted?
I don't think he should be prosecuted, but I would certainly oppose what he had done.
Why would you not prosecute him, sir?
Because I'd be very cautious and careful about prosecuting people for bringing information to the public.
Supposing, though, that it harmed or effectively ruined that policy at that delicate moment.
I think that would be very unfortunate, and I can conceive of circumstances under which prosecution would be legitimate, but not
What
the
if
ones you've
Otto, but not
described.
in any case in this one, what if
Not in
Otto
that
Otepka had leaked his classified documents to the press rather than to the Congress? I think a rather important distinction.
Well, not entirely, because don't forget that Ellsberg did bring the material to the Congress for a year and a half before, yes.
But that's where
yeah.
Otepka stopped and Ellsberg didn't.
Because
what
the-
if
because
he
then
had
the
gone to
material-
the press?
That would have again been extremely unfortunate,
Would you
but I agree
prosecute?
with the other witnesses that he should
You
not
would
be
not
prosecuted.
prosecute.
No.
Is there...
I wouldn't have
what if
rewarded him with the
Ellsberg
blank
had
salary.
stolen the documents and sold them to newspapers simply for the cash involved?
Well, then I think you might argue that there was an element of robbery or something of that sort.
No,
But
no,
certainly
I'm not talking about robbery. The robbery is a specific crime, and you can commit it whatever your intention in the particular case.
Oh no, well,
I want to know if he had had merely cash on his mind, should he be prosecuted?
I think at that point he could probably be prosecuted
words,
for the
the
trivial.
test-
Just a minute, for the trivial and a very different act of robbery.
The test
I
then,
think we have time for one more
the
question.
test then is motive. Two-part question.
Motive and consequences.
And Senator McCarthy's motives, were they pure enough? So
No,
that
Senator
they
McCarthy's
were
motives
not?
were quite evil, and in
all
fact,
a question of
in
good
all-
and evil.
Absolutely.
And
in
you
all
and
of these-
Ellsberg determine which
No,
is
I
which.
think that's something for every American citizen to determine for himself. And
I
he should
think it's for
determine
the
it-
government.
He should
Thank you.
determine it by looking at the content of these papers.
And our laws.
Professor Chomsky, thank you. Mr. Rusher, you have 1 minute to summarize your case. Let's begin with Mr. Miller, who also has a minute, as luck would have it.
I understand why those who wish Daniel Ellsberg to be prosecuted prefer to talk about George Washington, China, the Middle East, derailing troop trains, and what if he'd sold it for cash. But that has nothing to do with what's going on here. In fact, we're talking about a system of government secrecy that keeps secrets from the people of the United States, secrets that are being used against them, the secrets that the Gulf of Tonkin resolution was a fraud, the secrets that there was a consensus on bombing at the time a president was urging bombing. We have a system now of selective secrecy against the people, and Daniel Ellsberg has embarrassed the government by disclosing the secrets that hurt the government, not the United States. There is no injury to the United States. In his person and in his action, What Daniel Ellsberg has done, in fact, is not to violate any law, but to bring us once again the ancient message of John, that ye shall know the truth, and the truth shall make you free.
Thank you, Mr. Miller. Mr. Russia, you have 1 minute. Very quickly.
Whatever else has been accomplished tonight, I hope we have succeeded in focusing your attention upon the real question at issue here, which is not whether Lyndon Johnson was a good man, and as I said, he was certainly no favorite of mine, or whether Daniel Ellsberg was sincere, which I do not doubt for a moment, but whether the laws of this country apply equally to everyone. If they do, then Daniel Ellsberg should have the courage of those famous convictions of his and stop trying to avoid trial for the crimes for which the grand jury has indicted him. If they don't, if our laws do not apply to men who commit crimes from political motives or who hold popular political views, then we are well on our way to having a government not of laws, but of men. The time to be lenient with Daniel Ellsberg will be when he has been convicted and is about to be sentenced. Then will be the time for the judge to take his sincerity into account in imposing a sentence. But until then, he deserves no less and no more special consideration than any other American.
Mr. Rusher, thank you. Gentlemen, it's time now for you at home to act, to express your views on tonight's question. Last year, the advocates received nearly 250,000 letters from people voting on questions that we debated here. Now, the question you'll be voting on tonight is this: should the government drop charges against Daniel Ellsberg? Send your yes or no on a letter or postcard to the advocates, Box 1971, Boston 02134. Tell us what you think. We'll tabulate your views and we'll make them known to the officials concerned with the issue. What each of you think is important. Remember that address, the Advocates, Box 1971, Boston 02134. Last spring, just before President Nixon announced his intended trip to China, the Advocates in a special 90-minute broadcast debated the question, should the U.S. accept Peking as the one government of China for all purposes? Of the more than 7,000 viewers across the country who sent in their votes, 2,696, or 38%, were in favor of accepting Peking as the one government of China, but 4,345, 62%, were opposed. Now let's look ahead to next week. Thanks to our advocates and our witnesses, I'm Victor Palmieri. Thanks to you. Good night.
Advocates as a program takes no position on the issue debated tonight. Our job is to help you understand both sides more clearly. This program was recorded.